All right, there we go.
I don't see. I was trying to see Dom Kalam. See,
Oh, it said in broadcast. Okay, it should be going. I don't know what's going on. Say we live. There it go. It finally clicked in. Okay,
so,
let me play it.
Yeah. In the courtroom, I stand bold. Self-represent, watch the truth unfold. Yeah. Moorish knowledge, writs on hold. Gavel banging, but my plea is cold. Yeah. Law book stack. I'm my own advocate. Govern itself. They can't manipulate. Two. Sovereign move, no attorney fees. Stuff.
Pro say Mo.
Proof say Mo's. Let me go back. Let's get it. What's going on, family?
What's up, fam?
Peace and love.
Peace and love. Peace,
Barghani, Islam.
Islam, Islam. Peace
Oh,
and love.
you know what it is. Your dynamic duo once again back on the scene.
Your
Brother,
Batman and Robin.
the Batman and Robin. The wait, what's it's the Joking and Murray.
Maury,
You feel me?
come on down.
Yeah. So we getting it in tonight. Today's topic, it was long overdue. We were supposed to do this show probably a little bit ago, but we had some issues. But today's show, we're going to be talking about getting arrested. You know, our favorite thing to do is get arrested. So we basically gonna talk about the process of getting arrested, what happens, what it really means to be arrested, and the following things that maybe the laws that surround it. So before we get into any of that, you got your thing you want to pull up? Stop sharing.
Um, yeah, I want to pull up my book. Do I go here? Let me go to Amazon. Share the. It's your boy back again. How to stop child support. Your boy, your King ALB,
Yeah,
right on how to stop child support. This book, I was having some trouble with it, trying to get it to print out. So it was. I don't know why it's still like that, but the Moorish blueprint is coming away. Your redemption to lost sovereignty. It's the Moorish blueprint series on redemption. And tonight we're gonna drop some hot topics. But go to Amazon and get the book "How to Stop Child Support" by your boy King L. Bay, and learn more about stopping your child support.
yes, sir. I've heard really good things about it, man. So let me share mine. All right, so also check out
Make sure
any.
you pull them all the way up, Chief. They only see the top of them.
I'm about to get it. I'm about to get to
Oh,
it.
okay.
Yes, sir. So these are all my books on Amazon. Please go check me out. I got a variety of different subject matters dealing with history, law, religion, religious history. Even dealing with like the newest book is dealing with melanated love and relationships. So just go check me out, Bandele Yobachi Elamine on Amazon, and just get any book that get anything that comes to you, that attracts to your eye. Just get it. Okay. So let's get into the subject matter today. Like we said, we're gonna be talking about uh, getting arrested, and I was going to show what what the definition is of getting arrested. Okay, we're gonna get into the first thing we're gonna do. First thing y'all should do is really go to your Black Laws Dictionary and just look up the word. So I'm gonna read it, man. You can stop me or go into whatever you want to go into. So the definition in the sixth edition, arrest is to deprive a person of his liberty by legal authority, taking under real or assumed authority, custody of another for the purpose of holding or detaining him to answer a criminal charge or civil demand. Hold on, did I put it up yet? Hold on.
No, you didn't. It wasn't posted.
Okay, hold on, y'all. I be trying to figure this new stuff out as the screen. Okay, let me get back to it. All right, so um, my apologies, y'all. So okay, so like I said, it's to deprive a person of his liberty by legal authority, taken under the real or assumed authority, custody or another for the purpose of holding or detaining him to answer a criminal charge or civil demand. State versus Ferraro. People versus Whipfler. It says arrest involves the authority to arrest, the assertion of that authority with the intent to effect an arrest or the restraint of the person to be arrested. Okay. All is required for an arrest is some act by officer indicating his intention to detain or take person into custody and thereby subject that person to the actual control and will of the officer. No formal declaration of arrest is required. Okay. Uh, all right. So, is there anything that you wanted to say about that, or go back and look at?
Basically, we need to understand what is the minimum contact in relationship to the arrest and how do they get such right under the presumed authority. And to examine this, we have to dive into understanding the elements and the principles of relationships and contract. So a lot of us don't really understand this, in which we're going to get into a little bit. Because when we talk about arrest, right, we need to understand once you get arrested, what do you need to do? And because I want to stay on topic, I don't want to get into like the driver's license stuff, probable cause or reasonable suspicion. Those are the two elements that normally that suffice to generally detain you. So let's look at detain as it relates to arrest, right? You want me to share the screen? Let me see if I can pull up the word detain,
Right,
right?
because it did discuss detaining is
Right.
a form. It seemed like it's a form of arrest.
Arrest, but it could be an element, but it's not fully recognized under this. So let me see if I pull up detain as it relates to the jurisdiction. Let me pull it up. Let me see. Um,
For
you
those
want to
watching,
stop? You want to stop sharing yours?
okay, go ahead. Are you trying to? Are you?
I'm sharing mine now.
Yeah. Once you do it, I'll add it. We'll add to the screen. It's just a delay, brother. That's all. There you go. Mine's still up too. Y'all, excuse us. I'm just learning how to use this particular platform. So, but regardless, please like and subscribe to the channel, please. All right, so we got detained.
Detain, to retain as the possession of personality. I want y'all to look at that. Detain, to retain as the possession of personality. To arrest, to check, to delay, to hinder, to hold, or keep in custody, to retard, to restrain from proceeding, to stay, to stop. People versus Smith, 17, California Appellate Court, Second Division, 468-62, P23. That's the case law. Um, so, in relationship to being detained, so we need to understand what is their talk, what's going on. So, under probable cause and reasonable suspicion. So we need to know the two differences, and then we need to understand what you need to do under the actions of an arrest. So what is reasonable suspicion, right? And I think we did a show on that.
We did do a show on it, but for just to go back over a little bit. I mean, I guess we can let the people know.
Okay, let's get into reasonable suspicion. Reasonable suspicion is a legal standard of proof in the United States law that is less than probable cause, but is more what in child and unparticularized suspicion or hunch. It is determined the legality of a police officer's decision to perform a search. Reasonable suspicion refers to a police officer reasonably justified suspicion that a person has recently committed a crime and is in the process of committing a crime or is soon going to commit a crime. It must be based on specific articulable facts taken together with rational inference from those facts. That's a whole lot in a nutshell. So, well, the officer has to then do what? He has to he has to say, okay, he is about to commit a crime. So one of the things that they love to do is say, um, when they do a traffic stop, I smell marijuana. They love that. They love to see, and because a lot of traffic stops end up in may end up in arrest. Um, they might have. I had a police officer approach me and said I look like this person. Could I please identify myself? And that was another thing that they used. They was walking around the community, and I was like, well, how many people do you? So you could go around doing that. So the officers would stop you based off a photograph, and see you doing something, or they say they smell marijuana. Um, these
Yeah,
are actions, and then probable cause is something like somebody like for example, what would give probable cause to rise to probable cause to make an arrest is a criminal complaint. Me going in and filing a criminal complaint against you would give probable cause for an arrest. Or the officer see you what they call plain sight. He see you did something in plain sight in which articulated it was a crime. So, for example, if I punched you in front of the officer, he could then arrest me on the basis showing that he had probable cause to make the arrest because it was plain sight. Let's say you were driving and you had a marijuana cigarette on the car seat. He can then look and see and say, okay, that look like that's rolled marijuana, and make a determination based on that to arrest you for having, if it violates the law, for having that in your possession. Like in some states, that's what they would do. So we need to understand certain elements. If you look like a suspect, he has the right. They said if they get on the KDT, MDT, they said that the suspect is wearing all black, has on a black cap. They can step. They say that he's a black male from the age 26, um, 35. They can, if you, if they feel like you fit that description, they could stop you, entertain you, and ask you questions. That's not probable cause for arrest, but that's probable cause for. I mean, um, that is reliable for a reasonable suspicion. Do that make sense, family?
All right.
So, so when we understand probable cause and we understand reasonable suspicion, we need to understand what's going on to so that we can process and collect evidence while we're dealing with the officer. So once he make the arrest, you want to try to remember as much as possible the day of that incident. And if you have a recorder on your phone, take and pull out your phone, right? Um, you don't necessarily have to bring the camera in his face. You can just put it on record. So a lot of you guys, we got resources today that we didn't have in the past that would allow us to utilize, right? So if you got a cell phone, some of us got car cameras, some of us got devices in our cars. Hit those devices so that when you speak to the officer, if he when he come to court, you keep him to what? Based on his based on the elements that he said he stopped you for. Because a lot of times they will pull you over and then say something. Your job is not to say nothing. Just record. Just ask him a question. If he asks you, oh, where was you going? I don't answer questions. I don't answer questions. You ask him, just ask him specific related stuff. You ask him the questions. Don't let him ask.
I got you.
You see what I'm saying?
Right.
So one of the things that you need to understand is like, okay, you stay quiet when he answers you questions, but you can ask him questions. Why did you stop me?
Right. Okay. I want. Let me get something in real quick. Let me get some. One of the things when we're talking about getting arrested, and the reason why we're going into the due process. I mean, not due, but probable cause, reasonable suspicion. The reason why is because you should know one of the issues with your arrest. Does it meet any of these requirements? Because those are one of the first things you're going to challenge. You see what I'm saying? You're going to challenge these things and see if there is any standing in court over these matters. So, like, if you really, like, the thing is, if you don't know what the law is, what your rights in regards to probable cause, reasonable suspicion. If you don't know, they will try whatever they can and do to get whatever they're trying to get done. A lot of times, officers will overstep their rights and bounds just to get the arrest because they know you don't know. Okay, so that's one of the things. Let me see what my brother.
But also, we got to remember, family, that they be trying to make quotas. y'all got to remember they're trying to generate certain cities, right? Certain towns. That's a part of their budget. So they make a lot of arrests and they're trying to meet quotas, right? So you need to understand like the best thing you can do is stay quiet and ask questions. This if he asking you questions, you just remain silent. When it comes down to just asking him questions, you don't answer any questions. He asks you for your ID, give him your information and stay silent, right? If um if he approach you for no reason, let's say you sit in your car and he makes something, have it recorded and just be quiet. You guys got to understand not to self-incriminate yourself. Stop self-incriminating yourself and putting yourself in the box where it's hard for you to defend yourself against these claims that the officers are making, right? You have to identify everything that's going on and be aware, be attentive enough so that you can understand what's going on. If you can record everything that's going on, that's even better. Because a lot of times they'll try to tell you to stop recording and stuff like that, but you have a right. You have under the First Amendment, you still have the freedom of press. So you got to remember that. And they can't stop you from your freedom of press to record and ask questions because they are public servants and their job is to maintain the peace, not obstruct justice or interfere or infringe upon any right that you have, rights that's protected under the Constitution. So a lot of times they will violate those actions because they know that we are unaware or unfamiliar, or they could just tell that we might be financially strapped and we don't have those resources in relationship to these things that's going on. So we got to better understand when we come into contact with police officers what we need to be thinking, how our mindset need to be in order to um, keep ourselves from self-incrimination. Because a lot of times you might not be doing something, but what you say may create a presumption that give the appearance that you was doing something. So it's better to keep your mouth shut and let the officer do all the talking so that you can impeach his testimony for perjury.
Exactly. Exactly. I also want us, us to think about what had just happened recently in regards to there was an officer. I mean, not an officer, but it was a brother that was in Ohio. Matter of fact, did you hear? I know you heard about this, right? About the brother in Canton, Ohio. That
Uh,
was. They said he couldn't breathe.
right, I remember that. Yeah.
Yeah, this happened like a couple days ago.
Yeah, it was something in this timeline. Was it a couple of days or 4 or 5 days ago?
Yeah, like a couple days, 3 or 4. I mean, like
Right,
Um, but this happens often to melanated people, and it's important for us to understand the law. Like, because one thing about it is, a lot of times we don't understand the law, and all we thinking about is emotion. Um, a lot of times we get frustrated because we're being approached by an officer for what it may appear to be no apparent reason, and we get scared we oftentimes, you know, think the worst, which is, I can understand, but it's the way we handle it sometimes because we don't know the law. I think because we don't know the law, we don't understand the amendments. Like what we're talking about today is about some of the like the amendments of Constitution. We're looking at we might even look at some of these legal cases, but the key is to understand the legal side so that I'm not going to act up. I'm going to fight them in court. I'm not going to try to handle it now. You know, so a lot of times it's the way we kind of handle situations because we're emotional about it. I kind of wanted to play the video. Let me see if I can share it. I wanted to play this video, and then we could talk about it, see what happened. But let me see. This video is about the incident that happened the other day. So y'all bear with me as I get through this. All right, there we go. So let me see if I can play this video. It's only like a minute and a half.
Hit that screen to make it bigger.
I am once it goes to I think it's just going this is like an ad or something.
Okay.
So y'all bear with me real quick. Let this ad go because like I said, I mean this ain't nothing but a repeat. We've seen this before. We just had George Floyd, a couple years ago, about 4 years ago. So here we go.
This body cam footage shows Frank Tyson, a black man in Ohio, telling officers, "I can't breathe," as he's pinned down and handcuffed. Soon after, reports say Tyson died in hospital. Viewers may find this footage disturbing. The Canton Police Department released a 36-minute clip on Thursday of officers apprehending 53-year-old Tyson on the evening of April 18th at a bar. Tyson was suspected of leaving the scene of a car accident. Officers were seen entering the establishment and after an altercation wrestled him to the ground. One of them placed a knee near Tyson's neck for about 30 seconds.
I can't breathe. I can't breathe.
Local media in Cleveland say Tyson died at a local hospital, though Reuters could not immediately confirm the report. The official cause of death has not been determined. The Canton Police Department did not immediately comment on the video. Local media say officers involved were put on administrative leave.
I cannot breathe.
The incident is the latest evoking memories of George Floyd's deadly encounter with Minneapolis police 4 years ago. That set off massive racial justice protests in various cities in the United States. Officers involved in Floyd's case were eventually convicted of manslaughter and other crimes.
All right. All right. So we've seen that. We watched it. What you think, bro?
It's just, I mean, it's problematic in our community. I've seen videos where other white assailants pretty much almost fight the police, and they use no none of those tactics where they got where they got somebody down, foot on their neck, foot on their back, saying that he can't breathe. They got him down or not listening to the assailant, or just using excessive force. Um, but I also want to show something. Could I share the screen? I want y'all to understand something too. So I want to share the screen
You
on.
don't have to ask me, brother. Just once
Okay,
once you share it, it pops up.
okay. So I want y'all to look at this. So a lot of you guys, okay, when it's dealing with a motor vehicle, Bureau to forward information to selective service, motor vehicles, right? This is dealing with driver's license. As used in this section's license include a driver's license, commercial driver's license, temporary instruction permit, or identification card. Any person under 26 years of age who was required to register with the Selective Service in accordance with the Military Selective Service Act of 1967 as amended upon submission of this application for assurance or renewal of a license is deemed to have chosen consent for the Bureau of Motor Vehicles to forward to the Selective Service the necessary information for such registry. Upon receipt of application of insurance or renewal of the license for any person under 26 years of age is required to register with the Selective Service System, the Bureau shall forward the Selective Service System in an electronic format the personal information necessary for the registration. Every applicant for a license shall state the submission of the application will serve as the applicant's consent to register with the Selective Service, if so required by federal law. The Bureau may accept money for the Selective Service System to pay any cost that the Bureau incurs in implementing such section. So the BMV, they get money when they forward your information to make a determination that you are a part. And if they deem that you are a part or you went to public school or any of that information, you are a part of the Selective Service. And what do that mean? Right? So let's go here. I'm gonna just go another.
So connect that to me with the arresting.
I'm just the connection is people got to understand like the application of understanding the selective service and their relationship with these contracts to understand what they need to be, how they need to be thinking and behaving when they get stopped, so that they'll understand the appropriate behavior, so that they don't further escalate the arrest into something else. So I'm just giving them some extra, gems, right? I'm just giving you some short gems, right? Some little gems, and just to show you that you need to look and do further research to associate it so that you would know that. So, just giving some additional facts. But when you get involved with an arrest, stay silent. Keep your mouth shut. I don't care when you get in there. Keep your mouth shut. Don't say nothing. Don't say nothing. Even with your fingerprinting, all of that, don't say nothing. Do not say anything. With anything, keep your mouth shut. Don't talk to the inmates. Don't say nothing. Keep your mouth shut.
Especially don't talk on that phone. You don't know that. Don't talk.
Ooh, that phone gets you in so much trouble.
So many people don't really realize how much they talk on that phones. But before we get in there, man, I wanted to address this swindle hoodwink. This dude is a fraud. He walking around here. He's got a woman. He acts like he's a Moor, but he's really a Albion, so called white person that goes around and he tries to disclaim or make fun of Moorish people. So I just wanted to show him on the screen. So if you guys see him in your um, podcast or whatnot, because I see him in various Moorish podcasts trying to be funny and say things, but um, I know who you are, bro. I got you.
Expose him. Expose him real quick.
Huh?
Can you expose him?
You mean like go to his page?
No, you ain't got to go to. I'm just saying, is there any? I
Like
mean,
y'all just go to his page. Like I mean, like you go to his page, you gonna see what I'm talking about. Like he's a Albion. I'm not gonna say he's racist, but you know, to say short version, listen to obey the officer. I mean, like like that's common sense. We understand that. We're not sitting here telling anyone to, go against an officer. Okay, that's one thing you don't do. It's like if you're getting arrested, you, you're already in a process of being arrested. Don't resist, especially if you're melanated. Don't resist the arrest. The purpose of this show is for you to understand your legal remedies. Okay, understanding what being arrested means from a legal perspective, and then the process in which you go through arrest, and on the court side, what are your remedies after being arrested? Because I thought you was you were innocent until proven guilty.
Right.
I mean, or am I wrong, Swindle Hoodwink? Are we not innocent until we're proven guilty? Do we not? Is this not a republic in which we get a trial?
Or
So
fair
if we get a
trial.
trial, then we have the right to defend ourselves. And
But,
if you understand that the best way to defend yourself is to know the law, I don't understand that. That's why I'm saying, like, don't come in here with that Swindle Hoodwink. Don't come in here with that. I ain't on that.
and the most of the things of the ignorance of the law is no excuse, right? On both sides of the fence. So you got guys like Swindle Hoover who's advocating certain things, but never advocate when the police or the authorities say that they are proper authorities or in violation of their public duty. When they're in violation, a lot of times that don't get exposed. A lot of times they break the law all the time. I see them break due process, do all types of things, and then they try to cover it up because
So
it's a systematic thing. So
right. So he saying he can't breathe. It was okay. It's okay. It's okay for him. He resists arrest, and so he's killed because of it.
and that's okay.
Yeah, I guess it's
That's
okay.
that's this is the mindset of these people coming into this community, right? In this into this show to our community in our space, and they are not protesting against the injustice, knowing that the imbalance of justice, how our community is really hindered by the imbalance, right? So, like, even in my state, okay, in the city where I'm from, right, the city was placed on a core rental because they killed like 9 to 10 unarmed black men for no reason or more. They got sued. So the state the FBI even contacted me, erased my whole driving profile because they knew it was based on racial profiling. Racial profiling. So we have to keep this in context. So when we talk to y'all, we're giving you understanding because knowledge is the key. Once you have these tools and this knowledge, no one can take it from you. Now you got the information to particularly, right, deal with things appropriately so that you don't get yourself in the crosshairs. So that's what education do. It help alleviate certain burdens that's placed on you when you have these tools and this knowledge. This is what y'all need to understand, right? So shut your mouth when you get arrested. They got some what's these guys? They some attorneys and they say shut the fuck up.
Right. Exactly. So I wanted to like just read a little bit though of this, right? Because this like I said, this is the most popular thing going on right now. This is recently happened. So, this is an attempt to make an arrest. So just reading it, it just talks about the authorities' body cam of a 53-year-old black man who died after repeatedly telling the police, "I can't breathe." Right? It says very reminiscent of the George Floyd. So this, like I said, this is common. It says Canton police identified uh, Bo. I'm not sure how to say his last name, and Camden Birch as the two primary officers who responded to the call. It says to start off the video shows officers approaching the car that had struck the pole and a bystander informing them that the driver of the car had fled to a nearby bar in the American Veteran Post. When the officer entered the bar, a woman asked them to please get him out of here, referring to Tyson. "We're going outside," one of the officers said as they approached him. Tyson refuses, yelling, "You ain't killing me. You ain't killing me tonight." As the officers move to grab him, Tyson knocks over a bar stool and demands they call the sheriff. So right here, like, just all right. What is your thoughts right there, man? Like, what can you say about this?
Um, I think the officers need to have um, training. They need to be trained on social, some kind of social type um, duty when approaching civilians. I think they need some kind of training, especially when it coming into our community, because we have a legitimate gripe, right? When it comes down to us dying in police custody. You
Okay,
know, it's too many of us, and I think when he knocked over the ball still, and he was a little, you know,
I mean, but doesn't that call for like? I mean,
yeah, it calls for them to take attention to that and to say, okay, we're not going to try to force this situation because what do it matter if the arrest take 5 or an hour to make, right? What difference do it make, right? They could have easily called the sheriff department and had the sheriff come out also to help deal with this, right? And found and came into a better
really?
resolution. So I think they don't have no kind of conflict resolution when
So,
it comes to us.
he wasn't in the wrong. You're saying the brother wasn't in any wrong. He didn't do any wrong.
It's I don't think I'm looking at it from a standpoint of right or wrong. I don't know if he was intoxicated. I think this is a form of intelligence, and we talking about making arrests. We talking about people's lives in hand. So I don't think, when especially when nobody is dead or there is no there is no victim into a situation like that. Do you have to use that kind of approach
Well, all
to
they did was grab. They said they went to grab.
right?
They
But
said Tyson refused to say, "You ain't killing me." So the officers moved to grab him. Tyson knocks over a bar stool. Then it says the officers attempt to handcuff him.
now think about this. You remember the guy? He was up. I think he was in Boston. Who went into the store, right? And he killed all them black people. How did they treat him? How did they treat him? And he just murdered like seven, like he killed a lot of black people. I think he shot like 10 or 12, murdered like seven. I can't recall the details, but they talked to him calmly. They didn't rush in there to try to get him out. They talked to him. He came out, and they gave him something to eat and all of this. And they took him to jail. There was no kind of force, no kind of slamming on none of that. And my whole thing, he just killed somebody. And he killed multiple. He was a serial killer at this point, right? But they had the compassion enough to deal with him in a certain manner. After he did the one of the most heinous crimes that you can do is take someone's life. And this guy, you telling me they couldn't back up and say, "Hold up, could we talk to you for a minute? Could you come outside?" Could they had took the situation to try to de-escalate it before they started to get a little more aggressive? That's all I'm saying to you. I think when it comes down to us, they have no empathy, no sympathy for our people that look like us. And they get very aggressive because I didn't been in the car with police officers that got I didn't been pulled out of a police car. Hey, boom, 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 slam, threw on the ground, handcuffed at a young age. Police, I didn't do anything. They thinking that we robbed the bank. It had nothing to do with us. The sergeant came up and said, "Really? Really?" It was like, "Well, this, that." He said, "This ain't even a car." And you pulled these, they took my guy's stuff and threw it all over the curb. All out, they took all this stuff out, spilled all type of stuff, and we had to get it up. They didn't even help us get it up. These are the things that I have seen. I told you I didn't have officers do all types of things growing up. So our community have a gripe because it hasn't been they haven't been friendly to us. It doesn't matter if you right, wrong, or indifferent. It doesn't matter. It's just constantly they have did this to us over and over again. And this just shows. And it's not gonna stop until something is really done about it. And we have to push the agenda. We have to make this officers really pay the price when they do that. Not just going to jail. It has to be something because these people are supposed to know the law.
True. I mean, I can't argue with you on that, brother. Um,
So
it's true.
back to the arrest part. We need to understand what you need to do. Once you get into there, you get arrested. What do? Like we said, stay off their phone. Don't communicate, calling people, saying a whole bunch of stuff on their phone. You can say things that get you incriminated on some other stuff that can get you indicted. Like I done seen with brothers in jail for one thing get themselves indicted on another thing by saying certain things, and the police take that stuff under that find probable cause to do what? Further make arrests. Go to their house and do a search just off of their telephone conversation.
So, I mean, so would you say that? I mean, for the sake of the show, and we're looking at his arrest or his attempted to arrest, is there things that he could have done that would have maybe stopped the situation or changed the outcome of the situation? I mean,
Um, I think we're trying to put something on the assailant or the victim here, right? He was in a bar. He was intoxicated.
I'm saying like if for the sake of the show, we're talking about being arrested, the things you shouldn't do. You say shut your mouth. You're saying do these things, do that thing. So just looking at the arrest, were there things that would have been done that could have maybe changed the outcome of it, or things that you would have said, well, maybe he shouldn't have did this. maybe he shouldn't have did that. I mean, there's nothing. I mean, because I get it that they was wrong for killing them, but I'm asking you, was to you that was that would you is that how you would have responded?
I but we're talking about he looked like he was intoxicated. That's from what I'm looking at it. If you want to look at the standard, if he was in a normal condition, I would say talk soft, try to engage the police in an appropriate manner, try to de-escalate the situation. Don't be super aggressive. You can ask for the sheriff, you can ask for a sergeant, and ask for that when you know to try. Even though they may arrest you, you can still ask for those things and try to de-escalate the situation. Just talk to them. Don't try to get them to don't get aggressive, because when you get aggressive, that's going to make them aggressive. So by him knocking over the stool, by him saying the stuff he was saying, I just feel like that that made the atmosphere um, a little more hostile. But in relationship, if I'm looking at that as a police, you got to understand what their duty is. It's to maintain and protect the community. Um, that's what they say. So protect public property. So if their job is to protect public property and protect, right, protect and serve, they should have understanding about de-escalating when these situations occur when someone is intoxicated or something like that, or they approach someone in a bar.
Right. Peace, sister L in Washington. I know. Appreciate you checking us out. Definitely. Um, I mean, like the approach that the police officers take against melanated people has always been aggressive. Um, however, I guess I'm saying, like sometimes the approach that we've taken, being that we know we're melanated, and that I mean, even though it's not fair, but we know kind of like our situation in this country. Um, the reason, and this is the reason why we should know the law, because it's like, well, if I can, if I can stay cool and just observe, then 9 times out of 10 they're going to violate my rights in some way. They're going to do something that I can use to my advantage in court, because I either get arrested and get a bond and get out or whatever, or be dead. I mean,
Or get seriously hurt, you know. So we got to understand that they get seriously hurt. I try to tell people you can get beaten, have brain damage, be permanently in a wheelchair, have a colostomy bag. You know, it's so many things that can happen. And I tell people some things is worse than death. You can be permanently disfigured, disabled in the bed.
exactly. I mean, basically what we're saying, just understand the law. So there was one more thing that we were going to discuss in regards to arrest, and I think that was the Miranda, right? Did
Yeah,
did you want
Miranda versus Arizona.
did you want to go into that?
Yeah.
So, like we said, please give a thumbs up, like the video, and subscribe. Let's get it in. This is the. Are you okay? Here we go. Let me put you on. All right. So we got Miranda versus Arizona. For those who don't know, and this is an old case now. Like this is what 66. This is old.
Right. What we need to understand about the right to remain silent, right? We have a right to remain silent and refuse to answer questions, right? And it says answer questions from law enforcement or court officials. It is the legal right recognized. So you got to remember this is a right. It's not a privilege or a benefit, it's a right. Explicitly or convention in many of the world's legal systems. So you have a right to remain silent. You have a right not to answer questions. You have a right not to self incriminate. You have these rights. So the right to cover some things, right? The right covers a number of issues centered on the right of the accused or the defendant to refuse to comment or provide answers when questions either prior to or during legal proceedings in a court of law. This can be the right to avoid self-incrimination, the right to remain silent when questioned. The right include the provisions that adverse
Could you scroll up?
interference cannot, huh?
Could you scroll up? Because we can't see all that.
Okay, right? It says the right may include the provision that adverse interference cannot be made by the judge or jury regarding the refusal by a defendant to answer questions before or during trial, hearing, or any other proceeding. This right constitutes only a small part of the defendant's rights as a whole. This is a small part of your rights,
I still
right?
don't see it. Did you roll? Did you scroll? Did you scroll up? Like
You
this?
still is that it? Is that it? Could you
Oh,
see?
it hasn't moved. I'm saying like move your screen up where you like you're
I
going
have.
down.
I'm moving my screen. You
Oh,
can't.
okay. It's just not doing it then. Okay. Let me I don't know what to take. I don't know why it's doing it, but
Let me stop it and reshare it. All right. Let's see why. Can you see that in blue?
yeah.
So it says the origin of the right is attributed from Sir Edward Coates' challenge to the ecclesiastical courts and their ex officio oath. In the late 1700s, it became established in the law of England as a reaction um, to the excessive of royal inquisitions in these courts. In the United States, informing suspects of their rights to remain silent and the consequences of giving up that right forms a key part of the Miranda warning. So this is something that your children should know. Your children, your children that run around here should know they should not talk to officers because officers are not your friends. So we need to understand that the officers only need to speak with adults. Your children should not be allowed to speak. And one of the things they will do is they will encroach children and become your friend. Give them food and beverages and stuff to give them to speak about something they may or may not know. Um, I remember when I was younger, the police charged us with something, had us sign some documents, and they they we was convicted under that. We didn't serve no jail time, but we had to do community services, and I'm like, we didn't even, they said some other stuff. So it's very important and crucial to understand the right to remain silent and understanding how to get people involved. This is a community thing that we need to know. So I'm trying to get everyone to understand the case, Miranda rights. This is a violation of your Miranda rights when the police fail to give you a Miranda warning on your right to remain silent. So, we have to be careful in understanding that you need to know this. So you need to never talk to the police about nothing unless it's necessary. If you're making a criminal complaint and you're causing the criminal action itself to be initiated based on your statements that you're filing a police report. If you're not doing that, you need to shut the hell up and be quiet.
Facts. So let me ask you this. Let me ask you this. Sometimes an officer, a lot of times they don't even give you your Miranda rights. You know, a lot of times, I mean, I've had issues where the officers haven't talked to me and told me my Miranda rights, and we'll argue that, but it doesn't mean anything in court. You know, what's that about?
Um, some states feel like that an officer don't have to give you such warning, but what I'm saying to you is, hold on one second.
I want to. I also let me say this too, y'all. I know I've heard that they may not tell you your Miranda rights until you are being questioned while you are in custody. So it may not be um, at the arrest that they tell you anything can be used against you. They'll tell you that, or they're supposed to tell you that at least if you're getting questioned about whatever you're being arrested about. So, you know, you're not supposed to be speaking to anybody unless you got legal representation or that you are legally competent yourself to know what to say and what not to say. And see, that's another thing is that, you know, knowing the law, knowing to be quiet, knowing the power of silence, not allowing the officer to, you know, get under your skin, not letting the officer antagonize you to allow you to uh, say things that you're going to regret that can be used against you. All these type
Or
of things.
just state. So to answer your question, because I know when you're going with that, right? But sometimes the court will say this in relationship to that: you were being detained, you wasn't being arrested. So the officer, those that doesn't apply in that situation. So a lot of times you will be in handcuffs and everything, and they be like, well, you being detained. You're not really being arrested. Or they might make it give the appearance that you only was being detained. So if you're being detained, you can answer you don't at no point answer any questions, right?
Right?
So you have to be careful until they tell you you are under arrest. They don't have to give you the Miranda warning. If
Right.
you say anything until they officially tell you that you are under arrest, they don't have to give you the Miranda warning. So you can be detained. An officer, because you hear him say this, well, I'm putting you in handcuffs for my safety, for my own safety, for your and my safety. I didn't have an officer put handcuffs on me and tell me that he was using the cuffs for my and his safety, right? So he said, I'm not arresting you. I'm just putting these cuffs on you for safety purposes. And I was like, why do you think I'm a threat? He just said, I'm just doing it for safety. So you have to be careful with speaking to officers because, and then how the court is going to look at it and the jury may look at it if you were being arrested. Is that considered arrest? And there's some gray areas. So anytime they stop you, that don't necessarily mean you under arrest. You could be just being detained to answer questions. You need to tell them, I don't answer questions. If you want to ask me any questions, here's my turn. Contact my attorney. May I contact? I refuse to answer questions. Put that on the record. I refuse to answer any questions. So if you think you by this stop that I'm going to answer any questions, right? I'm refusing. You want that on camera. So then they can tell you what they're doing. Because a lot of times they will detain you for a long time and say you was never under arrest, but you've been detained for an hour or over an hour. So don't get this confused to give them opportunity and ammunition to use against you. Just sit there and remain quiet. So that's what we have to do. Anything to say, Chief?
Go ahead, real quick. Go ahead, bro. Keep talking for a second.
So what I need you guys to understand is until the officers say you are under arrest, the Miranda warning do not count. So don't be talking. Shut your mouth. Until they say you are officially under arrest, you don't say nothing. No, period. Period. They don't have to give you no warning until they say you are officially under arrest.
Okay.
That's what you need to understand. So they can hold you there for hours because they're doing a investigation. The police can hold you up to 72 hours in jail and release you. I didn't have that happen. Well, they didn't arrest me. I'm in jail for they trying to figure out some stuff and then they let me go. And I'm like, man, y'all did all of that? Really? But they do that. This is the stuff that we got to get our children aware of and tell them to keep that. The police is not our friend in the community.
Gotcha. So, did you see that question up there, Francisco Anderson discussing? Said, what about Child Protective Services? She's in Washington, and she said the CPS always popping up at the schools, questioning so-called African American children. Are the children obligated to talk to them? No. I mean, in the short answer, no. Are you muted? I think you muted.
Right. Yeah. Nobody is obligated to talk to nobody.
Right. Exactly. Especially in schools, man. You know, it might even be best to even have something on record.
You need to have something on record. You need to have, see, this is why we need to understand these contracts to understand we need to have things in place when our children attend public schools because you in a public domain, you in a public jurisdiction. So CPS can come up there and ask questions, right? They can come up there and the children can answer them.
Islam, Islam.
So that can mess up everything, right? And they will use children testimony, right? They do it all the time. They can come up to the school, police officers, whatever, can talk to, and that's what we have to understand is when we go to these public schools, right? We're up, we are, we are at the mercy of the system, and we have to be aware of that. So if you got children that go to public schools, they can come up there and question your children. Yes, the children can refuse to talk to CPS.
Exactly. They got the right to remain silent.
They have a right to remain silent. They can't force children to talk.
And we got
And if they
people.
do so, that is a violation of their right. The children say, I don't want to talk, and they do something to coerce the children to talk. Let's say they hold them without feeding them. They say, I'm hungry, I'm hungry, I'm hungry. And they say, we feed you, right? And or in order for you to talk, that's a form of coercion, right?
Right. Right. Let me see what my man says. The man, he said we need to fill out a resignation of agent form and write a letter for revoking of the underwriter. What you think about that?
Um, that's all good, but that don't suffice when you making minimal contacts. You have to understand minimal contact. You must understand. You must understand minimal contact. You must understand minimal contacts, and I don't
So,
think people do.
hold on. Like, I mean, what do you mean by that? Like, you just saying? I mean, like, you saying fill out a resignation of agent form. So you saying, oh, if, what's that got? What's the difference between that and like not speaking to the agent or the officer or CPS or whoever it is?
It's basically if you refuse.
I'm not speaking to you, and I also have my resignation of agent form on record, revoking the underwriter. I'm just throwing it out there. I'm not saying you read it wrong. I'm just
I
not.
mean, you can do that. I mean, but being silent is acquiescence.
Silence is golden.
You see what I'm saying? So if you silent, I mean, is you performing? Ain't that a form of revoking? You see what I'm saying? So when you understand what your rights are, you know what to do. So I think we take a lot of we take a lot of credence to processes without understanding the full scope of how everything intertwines. So when we get into courtrooms and start doing things, we try to figure out and we try to use processes that may not get us nowhere. When one of the basic processes is shut the hell up.
That's the first one. So I okay. So I see where you're going with it. He's saying to remove yourself from the system and out of maritime amity jurisdiction. Okay, so we're on that aspect of it. I mean, I,
That's why
I
I said
totally
you
get I
gotta.
totally get what you're saying, bro.
But this is what I'm saying to you. That doesn't remove minimum contact. You know, we've been through all of this stuff, Chief. Minimum contact. This is stuff that
So
I
shutting the heck.
talk about.
So you saying shutting the heck up is
It's golden.
right, but it's what that's not. What's how are you in a jurisdiction or not in a jurisdiction by just being silent? Is that I mean, are you still not making minimal contact? Are you not making minimal contact because you are silent, or are you still within minimal contact because you're in their school? I mean,
So we got to understand this when you so you got to look at we dealing in contract law, right? If your children are registered to go to school, that's evidence that they're in a public jurisdiction. How could you challenge or say that um, you fill out a reform revoking that, but you acquiescence to the application? You could do all of that and still go back and come back into a public domain, and they're still going to have jurisdiction. So you have to understand the contracts in which we're under. Doesn't matter if you did all of that stuff, but you re contaminate yourself within the jurisdiction by acquiescence through certain actions, right? That's still going to suffice. The state or the government is still going to gain access and jurisdiction because you enter into a public domain and you receive a benefit from such public domain or privilege, right? So if we're thinking from that perspective, we trying to revoke and get out the system. Don't send your kids to public schools.
I mean, it's a contract. I mean, you contracted with with them, so that's gonna be minimum contact. Now he said, okay, so this is what. See, hey, we couldn't make it out. We couldn't make it out this show without some sovereign citizen dialect. Now I ain't saying that this is I ain't saying this is sovereign citizen, but
Build up.
it's
This is not so
sound like
much.
it. Huh?
Nah, it's not sovereign citizen.
I'm saying
Read.
it sound like it. What I'm saying, diplomatic immunity.
Yeah, that's kind of like, mm, yeah.
I mean, how to be a diplomat is you got to do some. I mean, I get it. You talking about filing this and that, but I'm saying like I don't think a diplomat is based off of these principles. Like being a diplomat,
No, that's dealing with
going
treaty
through the state.
rights. That's dealing with statehood and treaty rights and stuff like that, contractually by nation, by um, national standards, right? And through application of international law. Those are principles that's directly infused in that. But um, but you have religious immunity, right? So I think sometimes we try to overcompensate for certain things when we already have certain immunities available to us, right? Even through the rights of private rights of action, right? So we have that. So what we teach and what we understand, like I try to tell everybody, when you get into the courts, um, I tell people you got to know due process, the issues of due process, and getting around that. That's why I teach the due process suite. Once you understand the certain things and triggering that, and once you trigger that under the Sixth Amendment, nature and cause of action, right? Once you ask for the nature and then they fail to do those certain things, you go upon your due process suite. Failure to be heard, failure to inspect evidence, a failure to call witnesses, a failure to uh, right. They deny you a right to discovery, right? All of these different things encompass the due process suite. So when you understand that the due process suite, you don't have to. These are things that I don't get over zealous about anymore, right? Because I understand what's going on. I hit them with the due process suite, and I take away the jurisdiction. A lot of times, the court, the judge will try to challenge your position. I just hit him with an injunction and remove him out the way, and I file an injunction on due process violation. And the court, he is devastated from jurisdiction that now you take it out of his hands and you go to an appellate court and you have the appellate court review it. And now the prosecutor got to deal with that with these due process issues. And then you can argue this stuff, and then you can once you get certain things, it's a bunch of stuff that I do, recusal of the judge, it's all types of stuff. I hit them with the due process violation. This is why I teach the due process suite, so you will understand the due process suite. All of this stuff is due process issues dealing with substantive and procedural rights. Substantive can come in multiple forms. Substantive violations of contract, substantive language when they're changing the language of a statute, of a constitution, or whatever to fit a ability to then move a case. So let's get into this, since brothers, we having this conversation, because this is what we do, right? I'm gonna show y'all something. It's called abatement of a claim. right? King El Bay do this. We do this. So let's go to abatement of a claim, right? Let me see where did I got that. Let me see. Let me see. Do I got that abatement? So let's go here, right? Because this is what I do. I crush them all the time on these issues. This is what we do. Okay. Uh, what happened? What the hell?
All right, all right. I had to get off for a second, but I'm back, and bro, Chief Smoke, he was saying that all of it is a civil matter. No due process means no injured party. I don't care what the judge does. I will file an affidavit of disqualification.
I mean, you can do all of that, but I'm so. This is what I'm. This is what we do, right? Interruption. This is an abatement of claim. Interruption of a legal proceeding. An abatement of a claim refers to the interruption of a legal proceeding. It occurs when a defendant raises a matter that prevents the plaintiff from proceeding with the lawsuit at the time or in the form. I'm sorry, I keep that keep. It can be considered a defense. So, abatement of a claim. So I hit them with this, right? But I also, before I hit them with that, I hit them with this. We hit them with constitutional sanctions, right? So let's go over here. Let's talk about these things as it relates to constitutional sanctions, and this dealing with due process. So I'm busting down. So y'all want to hit them? Here you go. Bust it down, family. So I don't stop. We already know that it's all civil, but we talking about sanctions. Constitutional sanctions is a constitutional sanctions is a term used in the legal field to describe the intervention of an independent and super part actors, such as courts reacting to the violation of written constitutional norms with constitutional review. This type of sanction represents the threshold between positive constitutional law and customary law, constitutional law. Constitutional sanctions are essential procedures of constitutional review of the legislature, while customary law is more frequently referred to as the Constitutional Convention. So you guys got to understand this element and understanding when you hit them with a constitutional sanctions, right? So when they start violating the due process, I hit them with the constitutional sanctions. Did that show up, Bandalay? Did you see that constitutional sanction? Could you see this, Chief?
Oh, I have muted it. Yeah, I put it up. It was up.
Oh, so this is something that people don't understand. So I hit them with sanctions, constitutional sanctions. Okay, y'all don't want to tell me the nature. The prosecutor don't know the nature. So I'm gonna put in a motion to dismiss for failure to state the claim, and I'm gonna hit them with sanctions. When the court start trying to move forward, I'm gonna hit them with the constitutional sanctions. When he
Oh,
don't, then he don't. When he don't want to apply by the law, I throw the notice of injunction. I put his ass on notice that I'm gonna file an injunction, and now we're going to the appeal court to deal with these constitutional violations. I devastate the court altogether. Remove the shit out of his hands, where he can't speak on the matter. If he's going to be a belligerent judge and refuse to understand and recognize the constitutional requisites, where he's going to deny me due process, then I'm going to devastate it and I'm going to the appeal court to file an injunction. We're gonna hit him with the injunction, and we're gonna smash them on the injunction.
Exactly. Exactly. I know you over there blowing up.
So when you do this, family, right? When you understand this, you kill. You don't allow the court. You sometimes you're not going to make headway with the judge. It don't matter what you put in. You can file all of that. You can file a motion for him for the affidavit of disqualification. You can move for him to recuse himself based on those due process issues. That don't mean he's going to recuse himself. That's why you got to be able to file an injunction, because
I
sometimes
mean,
they're not going to comply. I
I
don't care
mean, the
what,
affidavit is not going to do it anyway.
right?
You can't just file an affidavit and that's it.
Right?
It's not going to work.
You got to file a motion to recuse. And then you got to have an affidavit to support the motion to recuse with the exhibits, with the transcripts verifying. A lot of y'all don't know you can do an affidavit of the evidence, an affidavit in lieu of transcripts in support of that. See,
Right.
I didn't did that. I didn't file an affidavit in lieu of transcripts and filed a motion to recuse the judge based on what I presented, and they tried to the judge recused himself because I knew how to set that up. But you got to have the motion to recuse, and you can do an affidavit in lieu of transcripts and file an affidavit in support of the motion to recuse, stating all the stuff, and do the affidavit in lieu of transcripts supporting the facts that you presented to the court. When you talk about people who know how to win cases, me and Chief know how to win cases. We know how to bust this down. We know how to butt black eyes. We know how to knock out teeth. We know how to keep people on the ropes. We know how to bust them down. We don't play that. When I'm going there, I'm going in for the juggler. We trying to bust and knock out teeth. We trying to do damage.
Now you got a brother saying, I'm gonna say, you got a brother saying,
He have
does
proof.
he have proof of this
Proof
work?
of what?
Have
What you
you
mean
ever?
proof of
Have
what? Proof
you
of
ever?
claim of the work? I'm a.
I don't know if he's talking about what you were saying or what the brother Chief was saying. Chief Smoke.
I don't know.
I don't know. I know as far as what he's saying. I mean, we've been to court several times. I mean, and this is why like going in there talking about filing affidavits. I've done that, and it doesn't work.
Affidavits do not move the
I
court.
mean, they're you need them, but yeah, but like he said, they're not going to move the court to do anything. That's not what they're designed for.
Affidavits are nothing but a fact-finding tool. This could be used as evidence.
Yes.
It's a sworn testimony. It doesn't move or ask the court to do anything.
Yeah. This is from
It's an evidentiary standpoint. It's if you look at the rules of evidence, it's a fact-finding tool. It's evidence, and you have to understand how to present evidence in before the court, or the court is going to consider it hearsay. So if you file an affidavit to do what? What is the affidavit in support of? What did you find? Where is the exhibits that support your affidavit? Along with your motion asking the court to do something based on the findings that you have discovered in the form of discovery or whatever you use as a fact finding tool. We do this. Like you're not.
see the key is the like the difference is these are things that you find in the Constitution. You'll find in the codes, the rules of procedure. These things you'll find in there. So it's not like out of the it's not crazy. These are things that you actually will find. And because of that, these things are recognizable by the court. The court will recognize these issues and they will answer the issue most of the time. Um, but when you're dealing outside of that, like I said, you're dealing with an affidavit as just on its face, just a plain. You're trying to use an affidavit to get the judge to do something. It's not going to happen, and that's based off of the experience. I have been in court and I have filed affidavits, and they're not effective in that way. But then if I do it in a motion and I use it in support of, then it becomes effective. That's just what it is.
All of these things that I'm talking about, you have they're in the rules of civil procedure, rules of evidence, the rules of criminal procedure. You also need to know the rules of superintendent. I don't know, in my state they're called the rules of superintendent. In your state they might be called rules, different rules. You must understand these rules in conjunction with the court rules. The court rules in itself. They have court rules, the local court rules. You must know all of them things and associated with that. Then you must know the appellate uh, rules of procedure, the Supreme Court rules of procedure. These are so that you are technically procedurally sound when doing everything because everything has what they call a time computation. That means it's barred after a certain amount of time. So if you don't know these things, you're going to be time barred and you won't be able to raise any of these facts in law. I got too much experience in winning and doing this to understand that you must be procedurally sound. This is why I talk about substantive and procedural due process from various understanding. If you don't know this, brother, then that's on you when you go to court. This is why you got people like me and T that is well rounded in this information.
Right. I don't know what kind of paperwork you had. I know there's a lot of paperwork going around. A lot of people. See, the thing is this: a lot of people done, have not been in court doing this, and if they have not been successful in court. But they will, tell you, hey, file this and file that, and you don't need to do this, and they'll tell you these things, but they have never been to court and they never tried it successfully. That's all I'm saying. You guys got to be careful with who you're dealing with, because if you don't know the law, then anybody can sound convincing, right? Like we can all sound convincing, and like we know what we're talking about if we throw a few things out there to somebody who doesn't know. And that's what usually happens to us, because we come into this and we don't know. Like we come into this knowledge without a foundation of understanding law. So you start hearing some lingo, and it's like, oh man, that's heavy. I've been victim of that. It really takes a lot of your trial and error, and it takes a lot of experience for you to go into court and actually accomplish it. Because somebody can even file something that might be legally right or have an argument, but what if you don't know how to argue it? You can't rely on the paperwork and just say, "Here, judge," and expect for the paperwork to work its magic. You're going to have to learn and understand how to argue that paperwork to the judge. You're going to have to convince that judge that you know what you're talking about and that this is the legal way. When I'm arguing is right, judge, based on this, and this, and this. Not, here, judge. I got this motion that you got to read, and you should just let me go. It don't work. It doesn't work that way.
There is no silver bullet. The judge can know when you didn't write those motions. They know. They know. When you get up there and they know. Because a person, like when I walk in there and they hear me speak, they know. It's a difference. They know, like, oh, yeah, it's a big difference. I know when to object, how to object. I learned that because all of this stuff is dealing with plain error. You dealing with this stuff on appeal. I'm not trying to go to appeal. I'm not trying to appeal. I'm not trying to go to trial. So my issues is devastating the court by understanding that there are constitutional sanctions that I can use and devastate the courtroom when they fail to adhere by the Constitution that created these three branches of government. That it's a constitutional mandate that they can't get around. I'm not trying to go to trial. When they're devastating due process, when they're violating due process, they have no rights that they can reach to. the court lost all rights. Jurisdiction has been severed. They don't have no rights when they're not following the Constitution requisites. Period.
Exactly. So I don't know. You see, we getting short on time though, but we do want to answer these questions and get into it. He says you don't have to prove anything with the affidavit of disqualification. The judge does.
What?
You seen it?
I, man, I listen. I don't know I don't know what brothers get
I mean,
move
maybe I'm
around.
wrong. I
I
don't know.
So you never heard of a motion for recusal? Or you telling me you gonna put in an affidavit of disqualification based on what? The judge don't have to know. Y'all got to, man. I keep trying to tell you, you're not. Listen, you can file an affidavit of disqualification if the judge decide he want to recuse himself because you have some pertinent information in that affidavit, and he feel like he needs to recuse himself. Maybe so, but most of the time they gonna deny recusal.
I mean, I'm with you, brother.
So now you're saying that the judge has no proof that they are not biased. But you don't have no proof that he's not biased. It's not about the judge. So what y'all got to understand, he who asserts the claim must provide the proof. So even as a defendant, right? If I make a claim, I still got to support my claim. I still got to support my claim. They be like, well, you ain't got to prove nothing. Yes, you do. If you're the defendant, if you say certain things and your attorney is speaking for you and your attorney do something, he still must assert and prove the claim. I've been in court 1,000 times. Dealt with appealing. I didn't dealt with federal, state appeal courts. I beat them under. It's only two things you go into the federal court for, right? Diversity questions. You're dealing with tort claims, diversity of citizenship, and you're dealing with questions of law. Those are the things that you're basically going to deal with the federal court under questions of law, trying to change the venue. When it comes down to, it said first off that they are not judges, they are actors. No, they are administrators.
Right, they're administrators.
They're not judges, they're administrators. So they have a right. See, that's what I'm trying to tell you. Y'all going in there saying all this stuff, and y'all gonna aggravate. I'm gonna tell you something.
Well, first of all, I mean,
Start pissing off the judge and see how it turned out on a lot of times. And especially if you don't know what you're doing, you gonna have a problem. Go in there and piss out the judge. I go in there and always be polite to the judge. How you doing, Your Honor? I go in there and I be
I
polite.
don't know about that. It's been some times you went in there.
I went in there and blast them, but I learned through those mistakes. Now that I got to be a little more, I learned that your approach to everything makes a difference. So, when the judge is being very, hostile and he's not, and you like, hold up, wait a minute. It's been time, but I learned through those mistakes that not to do that. Not to go in there and really just go in there and have a conversation with somebody. Just go in there and show them that you are not who they think you are, that you are not some idiot. I done had judges pull me to the side. Go to law school. You're wasting your skill set. You go to. I didn't had attorneys looking across from here. They had to go get two or three attorneys. They looking at me like, where does this dude come from? And that's now that I'm now that where I'm at now is just it's administrative process. So this is what I talk about, brothers. Y'all just bring up anything. So a lot of y'all don't understand about the administrative process. So what you talking about is called the notarial presentment or notarial protest. Y'all call it a administrative process, but it's called a notarial protest. Or you dealing with a notarial act, and the notary do four acts, or they do other, but the primary four acts that the notary do is protest, acknowledge, um, um, protest, acknowledge, attest, and presents.
Hold on.
These are notary acts that they can perform. So you talking about doing all this notary process stuff, man? It's like I get it, I understand it. If you dealing with a notarial presentment or a notarial protest act, and you did it in a FOIA request, and you already had your documents and your evidence already done, that's one thing. Like I know, listen, bro, you talking to a very experienced litigator. We're talking about somebody who knows how to really litigate up and down the track record. My track record, I have won more cases than I lost. I'm on the upper echelon of winning. I know what to do. Criminal, civil, all of that. Drugs, all of that. Guns, all of that. All of it. I know what's going on. I try to tell people don't go out there and hurt nobody. DUIs, I didn't pretty much seen and been through a lot of that. So I'm trying to get you about understanding contract law, brothers. So y'all going there like there's so many things you brothers ain't understanding with these contracts, and y'all don't understand corporate corporate law, administrative law. Y'all don't know um, um, constitutional law. You know, substantive law, um, remedial law. Um, I could just go on these various areas of law. You know, y'all talk about jurisprudence, and we break this stuff down. So we I crushed. I listen. I crush. When I come and say Hawk smash, I come and Hawk smash. This is what I do. It's not a lot of people talking about proof of claim and doing all that stuff. I'm telling you right here. I'm telling you, I do a due process sweep and I crush them, and I hit them. I get them. We're not going to trial. We're not going to trial. I'm not going. We ain't doing none of that. We're going to hit them with an injunction. We ain't going to trial. Criminal, we gonna hit them with due process, and we're going to file an injunction. We're not going to trial. We're gonna request the appellate court under an en hearing for all three judges to make a ruling and a finding of facts based on these due process issues that we presented. And then you got to understand in my state under a affidavit. So let me show these people something.
I'm gonna hold.
Like I just
I think I want to show him something. Let me see this.
but show
Yeah,
them that.
I wanted to bust that injunction real quick since we talking about injunction, right? So if y'all want to understand what the injunction is a court order requiring a person to do or cease doing a specific action. There are three types of injunctions: permanent injunctions, temporary restraining orders, or preliminary injunctions. So a temporary restraining order, TRO, and preliminary injunctions are equitable in nature. They can be issued by the judge early in a lawsuit to stop the defendant from continuing their allegedly harmful actions. Choosing whether to grant temporary injunctive relief is up to the discretion of the court. Permanent injunctions are issued as a final judgment in a case where monetary damages will not suffice. Failure to comply with an injunction may result in being held in contempt of court. Okay. So, I just want you to understand what an injunction because we throwing a term out there. So it's used to uh, restraint or to
It's
uh,
a it's another form of equity. It's an equitable. It's injunctions is a form of equitable relief when the court is not utilizing or not in compliance with due process. That makes the trial fair. It's a form of equity, fairness. So I be hearing brothers talking about, I'm going to a chancery court. I'm just going to use an injunction. Same difference. When the court is not being fair, they're being biased. I'm going on the constitutional sanctions, and I'm making them comply and making them behave under constitutional grounds. Now, have I had filing an appeal with the appeal court? They didn't rule on it. I done had where the appeal court never made a ruling. And what happened with the case? The prosecutor couldn't do nothing. The appeal court had to, they never made a ruling. So I told him, I said, since they want to keep it in limbo, let them keep it in limbo.
I got you.
You see what I'm saying? They didn't want to rule on it. And I did this several times where they didn't want to rule on these matters, on constitutional matters. And that the court do not gain jurisdiction until the appellate court make a decision.
Right.
You see what I'm saying? The appellate court got to make it file. You file the injunction. The appellate court gonna deal with the matter, and you gonna keep it pushing. You gonna file a notice of an injunction. You gonna
Exactly.
you gonna hit them with that injunction. You gonna hit them either with you gonna hit them with a permanent injunction or a preliminary injunction. A T a temporary restraining order. That's not what you're gonna file. You're gonna file them on the ground of permanent injunction on the grounds that they failed to give you due process and that they failed to state a claim and that you raised all these issues before the court and now you want this case dismissed with prejudice on the grounds that the court has devastated themselves from jurisdiction based on due process violations. And since they can't break the law to enforce it, then due process must stand because I didn't read too many case law that the court says this. Only thing the court care about is affording you due process. Your innocence and guilt is based on your peers. Either the judge is going to be your jury, or you're going to be tried by a jury of your peers. That has nothing to do with anything.
Right. I got you. So, hey, did you want to show something?
I was going to show
Okay.
affidavit in lieu of transcripts. Let me see if I can pull that up under the civil rules of procedure and under the let me see and under the rules of evidence. But you have to file.
Y'all, please like this video and please subscribe to help our algorithms.
Open. Let me see. I'm trying to find it. Let me go to civil rules. I'm gonna show you this. I thought I had the civil rules pulled up, but I'm gonna show y'all. It's under. Y'all gotta understand. I think that might be the local rules of the appellate court, but let me go to civil rules, Ohio civil rules of procedure.
We gonna wrap it up in a minute too, bro. I know we've been on here almost 2 hours. Dropping some jewels on them. So
Yeah, I'm about to. We about to get done. I just want to show them this, like just going through all of this stuff under these. So a lot of y'all got to remember there are local rules, like the appellate court got local rules too. So you better read those, like those local rules. So let me go. Not findings of 53 magistrate decision.
yeah, contract law all day. Definitely, you right on that, brother. Contract law all day. Contract law.
Contract law.
Okay, I see.
Magistrate. So we're going to go down to this 53.
There we go. Yeah, this video crazy. Yo, it's crazy. We went
So,
in on this.
so let me go in and show y'all. Right? Specificity of objection. An objection to a magistrate decision shall be specific and state the particularity on all grounds for objection. Objections to the magistrate factual findings, transcripts, or affidavit. An objection to the factual finding, whether or not specifically designated as a finding of fact under Civil Rule DB3A, shall be supported by a transcript of all the evidence submitted to the magistrate relevant to that finding, or a affidavit of the evidence if a transcript is not available.
Exact, exactly. And now, y'all, I know he's used this before. He went in court and argued, and they really was going after him. Like they didn't want to use his affidavit. They wanted him to get a transcript. You know why? You know why, y'all? Because it costs money, and they wanted him to spend that money on that transcript. But he could have did an affidavit of the evidence.
And then we'll get into the other stuff at another time with the appealing court under appealing rule C. But like I told you, I'll do this. It says, with leave of the court, alternative technology or manners of reviewing the relevant evidence may be considered. The objecting party shall file the transcript or affidavit with the court within 30 days after filing the objection, unless the courts extend the time in writing for preparation of the transcript or other good cause. If a party filed timely objection prior to the date on which the transcript is prepared, the party may seek leave of the court to supplement the objection. Y'all really, it then says, waiver of right to assign adoption by the court as an error on appeal. Exception for a claim of plain error, a party must assign an error on the appeal court for adoption of factual findings or legal conclusion, whether or not specifically designating as a finding of fact and conclusion of law under 53 DB3 A2, unless the party has objected to the finding or conclusion as required under Civil Rule 53. Y'all don't really want this, man. I tell y'all, I do this, brothers, sisters. I do this. I do this. We come out swinging. We do this. We tell them, put them up, put them up, put them up.
This nigga.
We come in there and we make them bow down.
Okay, Ice Cube.
For real. Where the court had to understand, hit them with these injunctions and hit them with these rules. What I tell people, we are procedurally sound. When I go in there and I bust them, I'm procedurally sound. So when we hit them with this, we ain't going to trial. We're gonna ask them for the nature. We're gonna put in a motion to stay trial on grounds of due process violations. We're gonna hit them with all the necessary tools, man. This is what I'm trying to tell you. I don't lay down, I get down.
That's right. That's right, y'all. So, man, we're getting close to that time. Appreciate y'all tonight. It's been a good show. Yo, KB in the building. Appreciate you coming through, KB. You know what it is. We're gonna have to get together soon. Um, but right now we're gonna, this is the end of the show, man. Appreciate y'all. So Tuta Nana, peace and love,
Peace and love, everybody.
and we out.
We out. The dynamic duo strikes again.
Yeah. In the courtroom, I stand bold. Self-represent, watch the truth unfold, yeah. Moorish knowledge, writs on hold, ayy. Gavel banging, but my plea is cold, yeah. Law book stack, I'm on advocate. Governing self, they can't manipulate. Two, sovereign move, no attorney fees, stuff.